Welcome students on this program known as Darasa Online. My name is Aaron Mwaituka. I'm a commerce teacher. Joining me today is I'll be making a revision. Our topic today is called contract of sales, and I've prepared various subtopics which I'll be revising. And in this topic, what you need to know is that it is divided into two parts. The first part is called contracts in general, and the second part is called contract of sales of goods. So I will focus very much on the first part about contracts in general, whereby I will be explaining various subtopics which I've prepared, and in the process I will be giving some questions and I will try to give the suggested solutions. So join me as I will be doing the revision. So the topic is called contract of sales. Subtopic is called elements of a valid contract. So to start with, I will start with a definition of a contract. So what is a contract? What is a contract? So generally, when we speak about a contract, we say there must be persons who come together. They agree on certain terms, and after agreeing on such terms, we call them terms and conditions. After agreeing, they have to make sure that their agreement is valid. So the agreement must be witnessed by the law, or it must be witnessed by the lawyer. So we can say a contract is an agreement between two or more persons which is legally binding. So this is our definition of a contract. Now, as you can see, in this contract, we have some important terminologies. So we have to explain what it means by legally binding. As I introduced, I said when persons come together, they may have their terms upon which they will agree, or we can call obligations. So after agreeing, to make their agreement valid, it must be witnessed by the law. So that is why we say legally binding. So, and we say not all agreements are contracts. So it is for this reason. So it does not mean that any agreement is a contract. It will be, an agreement will be a contract only if it has been witnessed by the law. So there has to be witnessed by the law. This is what will make it a valid contract. Another thing is about agreement. An agreement is a basis of a contract. So as you have said, those persons must agree. So in an agreement, what you need to know, we have what we call offer and acceptance. Offer and acceptance. So in an agreement, one person, we call him or her offerer. This person must make an offer to another person, and that other person must agree. So the one who will accept the offer, we call him or her the offeree. The offeree. So this is the base, as we have said. Agreement is a base whereby for an agreement to be in force, so the two sides, one of the sides must give an offer and the other side must accept. Must accept. So once accepted, then an agreement will amount to a contract. Another thing which I mentioned is about terms of stipulation. Terms of stipulation. In a contract, there are terms which both sides must agree upon. So these terms will lead to what we call obligations. So which means each of those sides will have the obligations or the duties to perform. So we can see, we say there are, in a contract, there are rights and obligations. Rights and obligations. So in a contract, there are obligations whereby we say these are duties. These are duties which either of the parties must perform. And the rights are the benefits. The rights are the benefits which after performing, then the side which has performed is entitled to receive the benefits. So you can see what is formed there, there must be these rights and obligations. So the end result is when they will start doing or they will start acting in their contract, if either of the parties will happen to violate the duties or the obligations or will fail to perform the duties, so it means the contract may come to an end. It may be cancelled. Why? Because these are the things which the two sides have agreed upon. So generally speaking, as we have said, this is what we mean by a contract. Now another thing, now the subtopic, as we have said, we are going to explain is about elements of a valid contract. Elements of a valid contract. So we are going to see, for a contract to be valid, what are the features? What are the things which will make it valid? Number one, as we have seen, there must be offer and acceptance. Offer and acceptance. This is what I just explained, that the two sides, one of the two sides must give an offer to the other person, then that other person must agree or must accept the offer. Otherwise, it is not going to be a contract. So it is very much based on an agreement between the two sides. One side must give an offer, whom we call the offerer, and the other side must accept. That other side which is accepting we call the offeree. So this will form a valid contract. But of course, this is just a base. There must be some other things which will follow, as we said, that it has to be legally binding. Now here I have a question which will guide us into more discussion about offer and acceptance. So the question is, so this is the question. Briefly explain the rules governing offer and acceptance. The rules governing offer and acceptance. So there are some guidelines which must be following when making the offer and acceptance. Number one, what we can say, the one who is making the offer can make it either generally or to specific persons, but acceptance must be made by specific persons. It means one can make an offer to a number of people, let's say about 10 of them, generally. Now, when such persons are accepting, they must accept individually. Specifically, each person must write an acceptance. They must not accept as a group. So we say the offer can be made generally or to specific persons, but acceptance must be made by specific persons. So this is the first rule governing offer and acceptance. The other one is that the offerer, the person who is giving an offer, can decide to attach a condition, but that condition must be made when he or she is making an offer. The reason is, in contracts, when you have made an offer and that offer has been accepted, so you are not supposed to come later and add other things. So if there is any condition which one is adding, it must be notified from the very beginning when making an offer. So we say the offerer can attach any condition but it must be notified when making an offer. When making an offer. Must be notified when making an offer. So it must be communicated. So the one who is accepting must be notified. So that was the second rule governing offer and acceptance. The third one is that usually no contract can exist until the other side has accepted. So there is no contract when you can say the offerer has just made an offer and he assumes that he is already in a contract. It cannot be that way until when another person has accepted. That is when it will be counted as a contract. So we say no contract exists until when acceptance is made. No contract exists until when acceptance is made. The fourth rule, we can say usually the offer, as you have said, the offer can be cancelled. So we can say the offer can be revoked anytime. The person giving an offer can cancel the offer anytime because of some reasons. But what is important is that when he decides to cancel the offer, he or she must communicate that this offer is no longer there. So the offer can be revoked. The offer can be revoked any time. Can be revoked any time, but it must be communicated. Must be communicated to the one who is accepting. To the one who is accepting. So this is the fourth rule. The fifth rule, as you can see, we have been saying on the side of offer. Now on the side of acceptance. Here, the one who is accepting must not put any condition. So acceptance must be unconditional. Why? Because the suggestions which are given to the one who is accepting, they have to be accepted the way they are. When the acceptor or the offeree tries to put some other conditions, we call it, he is always making what we call a counter offer. He will also be making an offer again to the one who suggested or brought forward the offer. So that is why we say the one who is accepting must not put conditions. So here, acceptance must be made unconditional. Must be made unconditional. There shouldn't be, for the side who is accepting, there shouldn't be any condition, because otherwise, in doing so, if he puts any condition, it will be as if he is also giving the offer to the original offerer. So it is going to be what we call a counter offer. Then the last thing, or the last rule about acceptance is that usually there is a time frame which is kept for acceptance to be made. So the one who is accepting must accept within the time stipulated. So usually there is a time limit for one to accept. So which means if that time has lapsed or has expired, so automatically the offer will be cancelled. So the one who is accepting must accept according to the time stipulated. So acceptance must be made based on the time stipulated. On the time stipulated. So remember, we are discussing about the elements of a valid contract. So this was the first element. The second one is called consideration. Consideration. So in a contract, as I've said before, there are benefits and duties. Now when we say a consideration in a contract, we mean it can be something which is given for exchange. For example, there are two persons who are doing a business. One will deliver the goods to the buyer, then the buyer will pay the price. So when the buyer pays the price, we call it a consideration. So something which is given for an exchange. So is something given for an exchange. For an exchange. The third element is capacity of parties to a contract. Capacity of parties to a contract. So for a contract to be valid, the parties, those persons who are engaged in a contract, they must have what we call legal capacity. They must have what we call legal capacity. Legal capacity simply means one or those parties who are in a contract must be of age. So by legal capacity, we consider age. Usually, age has to be 18 years and above. 18 years and above. That is one. Two, one must be of sound mind. So if a person is of unsound mind, then we say he is not capable legally. So this is the other thing which forms an element of a valid contract. Then another element which is the fourth one is called possibility and legality. Possibility and legality. Now for a contract, when we say possibility, for a contract to be valid, it must be possible to perform. Possible to perform. It must be possible to perform. Otherwise, there can be some situations which may make the contract not be possible to perform. For example, if there is a law which has been passed in a country which forbids something, then eventually the contract won't be possible to perform. On the other side, when we refer to legality, we are saying that the contract has to be legal. Meaning to say there are some contracts which when one is trying to engage in a contract must avoid. There are some contracts which can be illegal contracts. So such contract one should avoid. For example, those contracts of criminal nature or the contracts of corruption practice. So these are the things which one needs to avoid. So the contract to be valid, it has to be legal. And the last one is called absence of fraud or mutual mistake. Absence of fraud or mutual mistake. It means there has to be absence of mutual mistake. Mutual mistake means the two sides or those persons who are in a contract, they should not make a mistake as to the understanding of the subject matter. They should not make a mistake as to the understanding of the subject matter. So the parties should not make a mistake as to the understanding of a subject matter. Subject matter in contracts is an object which the two sides are dealing with. So object which the two sides are dealing with. Okay, let's go for a short break, then we will come back. Welcome back as we are continuing with this revision. So the revision is about the contract of sales, and we are going through various subtopics. So far we have completed the first subtopic. Then let's move on to the other subtopic. This subtopic is called remedies for a breach of contract. Remedies for a breach of contract. So, as we have said, in a contract, there are terms of stipulation, or you can say there are obligations. Now, if either of the parties or one of the parties has failed to fulfill the obligations, so in that way, it will amount to a breach of a contract. He or she will be making a breach of a contract by not fulfilling the obligations. Now, because of that, the other party, we use the word the injured party. So the injured party, the one whom the other side has not done or has not completed his obligations, will look for what we call remedies. We look for the remedies. It means he or she will try to recover from the position. So remedies means to recover from the position. So the injured party must look for how he is going to recover as a result of the other party not fulfilling his or her obligations. Now, there are various ways. The first way to do, we call refusal of further performance. Refusal of further performance. In this way, it means the injured party will refuse to continue doing some actions or some obligations as they agreed. Why? Because the other party is not doing on his side. So the injured party will refuse, and again at the same time he may also resist the actions which are done by the other side. So this is one way of looking for the remedies. But the second thing is to claim for damages. Claim for damages. So the injured party must have done some obligations. So the only way to recover is to claim the equivalent to what that injured party has done. So claim for damages, the injured party will claim the amount equivalent from what he or she has done. Amount equivalent from what he or she has done. The third thing the injured party will do is to persuade the other party to perform. Persuade the other party to perform. So this means the injured party will do what we call convince will convince the other party to do as per their agreements, or will convince the other party to fulfill all the remaining part of his or her obligations. Then the other remedy is called injunction. Injunction. An injunction is a court order, so which means the injured party will rely now from the court, will go to the court. Now, an injunction, the court will order the other party to stop doing any action or doing any further actions. So we call it injunction. So it is a court order. The court will simply order that other party who has breached to stop doing some further actions. So we say is a court order to stop the other party from further actions. So this is the other remedy the injured party will look for. The last one is called rescission. Also, this is a court order, but it is done in some other ways. In rescission, we say the court will set aside the contract. So it will set aside, like the two parties or whatever they were doing, the court will set aside, and it will restore what we call status quo. So the court will set aside the contract and will restore the status quo. So here, the court will set aside the contract and it will restore a status quo. Status quo. Status quo simply means the situation as it is now. So all the contract will be set aside, and then the court will order the situation or to do according to as the situation it is now. So these, as you have seen, these are the remedies for the injured party which he or she may look forward in order to recover. Now, then let's move on to another subtopic. Another subtopic is about discharge of a contract. Discharge of a contract. Now, by discharge of a contract, we simply mean the contract may come to an end. The contract may come to an end. Now, we are going here, our concentration is to see various ways in which the contract may be cancelled, or various ways in which the contract may be terminated. Now the following are the ways. Number 1, discharge by performance. Discharge by performance. Here it means the contract will come to an end when the two sides have done or they have fulfilled their obligations, and each of those sides has received his or her benefits. Remember, we said in a contract there are rights and obligations. So when the two sides have fulfilled their obligations, they have done their obligations, and each of the sides is satisfied and has received the benefits, then in that way the contract may come to an end. But however, here the thing we need to know is that usually the contracts are renewable. So after, if they are satisfied from whatever they have done, they may terminate the contract, but if they wish to continue, they may renew the contract. So this is one way where the contract may come to an end or discharge of a contract. Another way is discharge by agreement. Discharge by agreement. So this situation may arise as a result of one of the parties having some reasons. If one of the parties feels that he may no longer proceed, or he or she is not in a position to continue with a contract, then the two sides may sit together and agree that let us come to the end of the contract, or let us end this contract. So in that way, that other side must have the reasons to convince the other side to agree. So that is why we say discharge by agreement. Then the third one, discharge by breach. Discharge by breach. So as I have said before, this happens when one of the parties has not fulfilled his or her obligations. As a result, the other party may decide to discontinue with the contract, as we have seen before. So one of the party may decide because the other party has failed to fulfill his or her obligations. The fourth way is what we call discharge by lapse of time. Discharge by lapse of time. Usually, contracts are made to exist for a specified period of time. So when that time will expire, it means automatically the contract will come to an end. Suppose the two parties have entered into a contract of 5 years. So then after 5 years, that contract must come to an end. So this automatically will make it not to continue. And the last one is discharge by death. Discharge by death. This means that if one of the parties is dead or has died, so this will automatically make the contract to come to an end. Why? Because there is going to be no performance or no fulfillment of obligations from the other side. So when the other side has passed away, so obviously the contract will come to an end. So these are various ways which will make a contract to come to an end. And then after this revision, I'm going to give a question, then I will try to show the suggested solution for the part we have revised. So this is a question. So this is a question. Mr. Bakari and Mr. James entered into a contract. Later, it was discovered that the contract was void. As a commerce student, suggest various ways in which the two parties may discontinue the contract. So this is the question. Mr. Bakari and Mr. James entered into a contract. Later, it was discovered that the contract was void. As a commerce student, suggests various ways in which the two parties may discontinue the contract. So this question is obvious. It means what are the requirements? You need to know what are the key words. So like here we have the word void. A void contract, we can say, is a contract which is invalid, which means the two sides are not supposed to continue with their performance. So it is invalid. So void contract is invalid. And again here we are asked to suggest various ways to discontinue, because already the contract, the two sides cannot perform. So you are asked how you can help them to get out of the contract or to discontinue the contract. Now, to answer this question, you are supposed to explain about how the contract may come to an end. So it's all about discharge of a contract. So as we have seen before, discharge of a contract. So we said the contract may come to an end by performance. So discharge by performance. The other way we have seen is discharge by agreement. The other way we have seen is discharge by breach. The fourth way, discharge by lapse of time. And the fifth way, discharge by death. My dear students, we have come to the end of the revision about this topic known as contract of sales, whereby we have revised on the elements of a valid contract. We also revised about remedies for a breach of a contract, and finally how the contract can be discharged. Thank you very much.